The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, please be seated. Welcome to the Fourth Circuit, and we'll hear our first case, United States v. Jackson. Ms. Albro.
Thank you, Your Honor.
May it please the court, I am here on behalf of the appellant Jarvis Jackson. This is Mr. Jackson's second appeal in this case, which leads us to the reason we are here, which is an issue related to the mandate rule. And I'm sure the court is aware of the background of the case, so I will just jump right into where the issue arises, the difference between our position and the government's position. And that is that the mandate rule usually applies once this court has made a decision, the district court is required to follow that mandate. However, there is an exception, and that exception is if there is a dramatic change to the controlling legal authority. Mr. Jackson submits that there were two cases that were very critical to the decision in his case. The first one was Campbell, and that case held that attempted delivery is an inchoate offense that was part of West Virginia's distribution offense. It also held that the guideline 4B1.2, which defines controlled substance offense, does not include attempt as it was written at that time. There's one other case that was critical to the decision in Mr. Jackson's case, and that was a state court case. And as this court knows, when interpreting crimes of violence, violent felonies, and other predicate offenses that enhance sentences, this court is bound to look at the state court's definition of its offense. And in State versus Brown, the South Carolina Court of Appeals held that an attempted delivery is a distribution.
Counsel, can I ask you a question? And sort of with all due respect to your position, which I do understand, how did we not already decide this issue in Davis? I mean, in Davis, the defendant made the same argument. Campbell controls, and we have this state court decision, and in Davis, we said, no, for our purposes, at least, these are meaningfully distinct statutes.
Right, there's no doubt it's the same statute involved, and it is...
I think we referenced Jackson's decision in the Davis case.
I believe it was in a footnote that it was unpublished, so it wasn't binding. So my best argument to you is that Davis is not controlling. For one thing, Davis was very careful to talk about attempted delivery. Now, I think previously, attempted transfer is what got the Campbell court to holding that attempted delivery was the least culpable conduct under the West Virginia statute. But if attempted delivery has been held, which it has in Campbell, to be an inchoate offense, then Davis really couldn't address the statute 44-53-375.
I thought the distinguishing point between Campbell and everything else that's come after that is whether or not there's a separate state or federal statute that deals with attempts, which was not at issue in that first case.
Now, that is an issue that I think is probably the more problematic issue for Mr. Jackson. What I would say to that is that it's, first of all, it's wrongly decided. I know that this court can't do anything to rectify that, but I have to say that to preserve the record. But I would also say that there were other things.
So you're saying Davis is wrong?
Davis is wrongly decided in that it holds that attempts are, if they are codified elsewhere, that they cannot be included in other parts of the statute. And I noted there's a case, Nelson.
So that would also, under that theory, invalidate Groves.
Groves, I think, is completely different than the state statute simply because the Sentencing Commission didn't have any authority to not include 841 as a controlled substance offense. They were directed by Congress to do so. I believe that's noted in the Groves case. And for whatever reason, Groves does hold that an attempted transfer is not an attempted delivery. So I say that Groves doesn't apply at all because there was that distinction made. I would say the state statutes are separate from that for those two reasons.
May I ask you a question about, I'm just trying to get my hands around sort of the scope of the ruling that you're asking for. Your argument, the mandate rule is not really important to your argument, right? You would make the exact same argument in a first sentencing, that here I am in federal district court and I am just here to say that Davis doesn't control, Campbell controls. So whatever we decide now will not only apply in cases where there's already a mandate, correct?
Well, I think the easiest path for the court to decide is to hold that the mandate rule is in place because Jackson.
But the bottom line holding, your way of sort of, your argument for why the dramatic change in law doesn't apply is Campbell controls over Davis. And if that is true, then that would also apply to anybody's initial sentencing, right?
I think you can make a more limited holding that because Jackson used the controlling authority of Campbell, that's how the case was decided in Jackson. And they compared it directly to Campbell. So I would say Campbell controlled the decision in Jackson. In future cases.
Jackson, was Groves out when Jackson was decided? I think it came later.
4 days later, yes, Your Honor. And so I would say that if Campbell controlled in Jackson, going forward, other litigants are free to make their argument about Davis versus Campbell, but I think with this opinion coming out and relying directly on Campbell, that Campbell controls, because to the extent that Davis would negate whatever holding in Campbell was applied in Jackson, it can't control because Campbell's a published opinion first in time.
Right, and that is exactly the argument anybody would make in an initial sentencing. Campbell controls, it's first in time.
Well, I did try to divide it in the briefing where I tried to address the mandate rule and why the mandate rule applied, and then the additional argument of this is why Davis was wrongly decided. But to get back to to Judge Agee's question about the attempt, there's another issue, and it hasn't been addressed, but just to distinguish it for this court, I did not brief this, but I will say that 44-53-375 lists manufacture, distribute, and all of the substantive offenses. And then it adds, or otherwise, aids, abets, attempts, or conspires. And otherwise, according to Black's Law Dictionary, is kind of a catch-all phrase that means in other circumstances, in another manner. So I don't think that the attempt, the way it was defined in Davis, applies to this statute because South Carolina has included all of the substantive offenses, and then as a catch-all says, well, any other attempts or conspiracies or whatever that weren't covered in this first phrase are also not included. So I don't think South Carolina's intent was to exclusively use the second phrase for their attempt crimes. And I would also add that outside of the argument related to Campbell and Groves and Davis, that South Carolina actually has a case, Brown, that says an attempted delivery is a distribution. So outside of that analysis and outside of how the statutes might be interpreted compared to 841 or compared to the West Virginia statute, the state has held that an attempted delivery is in fact a distribution. And it's no different to analyze it under the categorical or modified categorical approach, how a state defines its law, than it would be if it was another crime of violence or a violent felony. So that is, the bottom line is Mr. Jackson's position is that the mandate rule controls, that Campbell and State versus Brown are the controlling authorities, and they have not been abrogated since the original opinion came out in his case. Notwithstanding that reason, Mr. Jackson also raised an unreasonableness of the sentence argument, and I think the record is clear that what he raised on his resentencing, which was post-sentencing conduct, including his clean record at the BOP and the fact that he had been doing programming at the BOP, and he asked for a variance to what the guideline would be if the court held that Davis controlled, was not addressed at all by the district court. The district court made a summary statement without further ado. I think Davis is right, and here is the sentence, and I believe that is an insufficient explanation, and his sentence should be vacated and sent back for that reason as well. And if the court has no further questions, I'm almost out of time.
Thank you.
You.
Got some rebuttal. Thank you. All right, Mr. Andrews.
May it please the court, the mandate rule exists to ensure the orderly operation of the judicial system and to give meaning and effect to the decisions of appellate courts. It is not created to give loopholes or end runs around the binding decisions of this circuit. That's why a longstanding exception to the mandate rule exists when new authority undermines or rejects the principal legal reasoning behind the mandate. And that's exactly what happened here. If a criminal defendant were sentenced tomorrow under the same circumstances as Jackson, there can be little dispute as to what rule of law would apply to the calculation of his guidelines, and that would be United States v. Davis. That's because Davis is the only published decision of this circuit addressing the question of whether South Carolina's drug distribution statute includes inchoate attempt crimes. The panel in Davis found it did not, and therefore that South Carolina distribution qualified as a controlled substance offense for the purpose of the guidelines. That is the law of the circuit. The rule that Jackson suggests upon this court, insofar as the application of the mandate rule goes, would freeze in time the state of the law in this circuit at the time that the prior panel opinion was issued in this case. And we would argue that goes directly against the policy that underlies the mandate rule, which again is to give meaning to the decisions of this court, to reinforce the authority of appellate courts and ensure that district courts will follow the law. Now, there's three primary problems with Jackson's argument on appeal. The first is Jackson's reading of Campbell is so broad as effectively to render Davis dead letter. Under Jackson's theory of Campbell, that analysis in that case, which of course dealt with a West Virginia statute, did not purport to apply to South Carolina law, renders nothing left of Davis, which of course is a published decision of this circuit and is binding law. Jackson also suggests that Campbell and Davis are irreconcilable, and that this court needs to reconcile these two decisions. But Davis has already done that. This court doesn't have a duty to reconcile those cases. Davis explained that Campbell is limited to the West Virginia statute at issue in that case, and that the South Carolina statute at issue here, which is on all fours with Davis, is in fact a controlled substance offense under the guidelines. So Davis has already ruled upon that question. Third, Davis is one of three published decisions of this circuit that have now limited Campbell to the facts as were argued in that case relating to the West Virginia statute. Groves, of course, is one of those, which dealt with the federal distribution statute, 841, but also Miller followed the same path as Groves and Davis in distinguishing the North Carolina drug distribution statute from the West Virginia statute at issue in Campbell. Under Jackson's reading of Campbell, it would apply to control virtually any statute that included the same definition of deliver, which includes those words attempted transfer. But as the court has now made clear in 3 published decisions, that of course can't be correct. Campbell is limited to West Virginia statute and the facts as they were argued and raised in that case. And so for those reasons, the district court did not err in applying this exception to the mandate rule and following Davis as the binding authority of this circuit and applying that rule to Jackson's guidelines in this case.
Okay, Mr. Anderson, let me ask you about the procedural reasonableness argument. Looks like the record's pretty thin from
It
your
is.
point of view. I mean, in terms of defending the trial judge. Where is there a careful consideration in this record of the defendant's post-sentencing conduct while incarcerated?
So, Your Honor, we would not
I believe
disagree.
I have the right case. I think, didn't he ask for a downward variance as well?
He asked for a downward variance in the alternative. So the primary issue at sentencing, if you look at the record, it's clear that the central dispute here was the legal dispute about what guidelines applied. There was a request for an alternative variance. And I will concede, if we are wrong that Davis applies and the lower guideline range applies, I don't think there's enough here on record to justify an upward variance. But if we're right, and of course it is our position that Davis applies, and this is a typical guideline sentence, we believe that based on the entire context here, and of course this court has articulated a number of times that these questions are very context dependent. What the district court had before him was a substantial amount of briefing from both parties, not just on the legal question, but on the 3553A factors. He acknowledged that all the briefing was on the record, that the parties had put their respective positions out there, incorporated expressly that record as well as the prior sentencing, acknowledged the 3553A
Saying
factors.
the judge doesn't have to articulate anything.
Not exactly, Your Honor, but I do believe there is a foundation in the law of this circuit. And we would point specifically to Hernandez, which is a case with a very similar record here. And we're not here to argue that it's a robust record. This is not a substantial record. Certainly the district court could have done more, but it is our position when viewed in the totality.
The court, under our precedent, has to make an individualized explanation. This is why I'm giving this sentence to this defendant, and here's how I've looked at the 3553A factors. And while all that may be kind of lurking in the record or the pre-sentence report, I don't see where the district court ever did any of those things. It certainly could have, but I'm not seeing where it did.
It's not in the record. That's correct. We would urge upon the court, when looking at the context here, that it's clear that the district court did in fact consider the 3553A analysis put forth by the government, as well as the one put forth by the defendant, acknowledged that he had in fact evaluated the 3553A factors in arriving at a sentence, and it was a typical guideline sentence. I mean, this court has said in prior opinions, Hernandez is one of them, that when issuing a typical guideline sentence, the court is in part relying on the judgment of the Sentencing Commission to that a guideline sentence is the proper sentence under 3553A for the typical defendant. And so when the court says this is a typical guidelines case, makes reference to the arguments of the parties,
I'm sorry, when the
that may
court
be
says this is a
sufficient.
typical guidelines case, so now you're referring to the first sentencing, right? Not this one?
That's correct, Your
Okay,
Honor.
This
That's
one
correct.
has
It's not in this
additional
one.
information about post-sentencing conduct, so there's no way that that previous statement can be said to apply to the full evidence in front of the judge on resentencing, right?
Well, Your Honor is correct that the judge did not reiterate that at the second sentencing, but the judge did expressly incorporate the record from the prior
I'm not sure
sentencing.
about how expressly it was incorporated, but even if it was, I guess, first of all, it couldn't possibly have accounted for the post-sentencing conduct. Second of all, he said just help me out there. In the first sentencing, it's a typical guidelines case. But also, if I'm wrong about the guidelines, I would vary by 50 months and come out the same way. Isn't there some tension between those two things? Either it's a typical guidelines case and should be sentenced in the middle of the guidelines, or it's not. But how can both be true?
I'll concede, I do think there is some tension there, and I'm not going to argue that there's not. And again, the record is not a model of clarity. Our position here is simply that it is not so unreasonable as to merit an abuse of discretion in this case. I'll say one final thing, and I understand the court's skepticism about this record. There's no doubt that it's light. If this case is to go back again, we urge the court to finally resolve the question that has occupied the parties and the court each time Mr. Jackson has been sentenced, which is this question as to what guidelines are supposed to apply. Our position is that Davis is the settled law of this circuit on all fours with the statute at issue here, and the mandate that should go back to the district court is to sentence in light of Davis. There's no further questions.
Thank you very much.
Thank you.
All right, Ms. Albro, you've got a little time here left.
Thank you, Your Honors. I would point out, related to the reasonableness argument, that on pages 7 and 8 in the reply brief, Mr. Jackson points to the Pepper case and the Blue case. And Pepper is a Supreme Court case which specifically says post-sentencing conduct is likely the most accurate indicator of whether a person will engage in recidivism. So, as Judge Harris pointed out, and as I pointed out in my brief, that wasn't addressed at all. No matter if this court presumes that the court did address all of the documents in front of it, all of the record, everything that was said at sentencing, it never said anything about Mr. Jackson's clean record at the BOP, and never said anything about all the programming he had done, and that's an important sentencing issue which should have been addressed. And I would also address the government's argument that Mr. Jackson has claimed Campbell is a very, very broad holding. And in fact, in some ways, it is a broad holding in that it held explicitly that attempted delivery is not included within the definition of controlled substance offense. So regardless of which statute you're applying, which state, federal, what have you, attempted delivery has been held to be an inchoate offense under the old version of the guidelines. And I do think there's one other issue that didn't happen but would be interesting. The government argued that all opinions, that the reason for the mandate rule is for everyone to have certainty, for there not to be constant litigation. But Mr. Jackson, he appealed once. He believed that the opinion that came out would apply in his case, and it was 4 months, I believe, until the Davis case came out. So if he had been resentenced within the time of Jackson coming out and Davis coming out, he would have received the benefit of his first appeal in that opinion. I don't know what the solution is to that. I just thought that was an example of something that really shows how the mandate rule should work, how Mr. Jackson expected the benefit of his decision, and he didn't get that. So unless the court has further questions, I have nothing more to add.
Thank you very much. The court expresses its appreciation to both counsel for their arguments, and we'll come down and greet counsel and then move on to our next case.
Nice
very
to see
much.
you.
Thank you very much.
Nice to see you. Very nice to see you. I haven't seen you in a while.
All right, please be. And we'll now hear United States versus Mayberry. Mr. Warren.
Thank you, Your Honor. May it please the courts. My name is John Warren, and I'm appointed counsel for appellant Cornelius Mayberry. This appeal raises two Fourth Amendment issues arising out of Mr. Mayberry's warrantless arrest and the warrantless search and seizure of his bag. The government urges this court to endorse broad and sweeping standards for both probable cause and abandonment. But the government's constitutional arguments are in conflict with this court's precedent and would erode the fundamental protections of the Fourth Amendment. First, I'd like to address the abandonment issue. This court has repeatedly cautioned that abandonment cannot be casually inferred. Instead, the government has the burden of proving abandonment through objective facts, words that are spoken, and actions. As we set forth in the brief, I think the district court really erred in three fundamental respects. The first is the district court placed, I think, significant emphasis on Mr. Mayberry's failure to claim ownership.
Can I ask you a question about
Yes.
that? Tell me if I'm wrong, but I assume that if he did claim ownership, say after he's arrested, he says, oh, I left my bag in the stairwell, keep an eye on it, I'm going to send a friend to pick it up. That would be highly relevant to the analysis, right?
If he did claim ownership, I think
Yeah.
that's right.
Then how can it be irrelevant that he didn't? I guess I'm just not understanding that. Why shouldn't the district court sort of check off, and also, he didn't do this thing that would have been highly relevant?
So I don't think it is a condition precedent to abandonment. I have not found any cases where courts even inferred that it was something that was necessary in any way.
But I just sort of read the district court as saying, look, I've got these sort of objective things, and also he didn't claim ownership, which is relevant. I mean, it's good to get that on the record.
So I don't think the failure to claim ownership is particularly relevant.
But it's the opposite of the thing that you think is highly relevant. He did claim ownership. I guess I'm just not understanding how it can be relevant if he did, but then it doesn't matter that he didn't.
Well, I do think it is a consideration that the court can take. I certainly don't think it's anything prohibited from the court considering. But I think what the cases say
Well,
is,
do you think the court here did anything other than just consider that factor among a number of others?
I think that the court considered that factor under a number of clearly erroneous other factors. I think the two things that I think are most problematic in this case are the objective facts and the inferences that were taken from them. And the second is the references to the post-arrest statements, or the alleged post-arrest statements in the R&R, which was adopted and incorporated, and in the court's order. Let me start with the intent to abandon and what the objective facts are. So the objective facts known were that Mr. Mayberry, who is unknown to law enforcement, he is not the person that the informant in this case identified, shows up to the hotel and walks inside.
Are you talking about your abandonment argument or your unlawful seizure argument, or both?
Both, but I think particularly I'm talking right now about the abandonment issue, because I think we have to look at what the objective facts are when the bag is seized and then searched.
Well, are you saying that abandonment can be temporary? I mean, what is the legal principle of abandonment that you're relying on? I mean, is it an all or nothing proposition? Either you abandon for all time or you don't? Or is there a mid-ground that you're trying to argue here to us?
I think that abandonment by its very nature is permanent. I mean, that's what the cases have said, is that it is when a person demonstrates through objective acts and or words an intention to permanently abandon a reasonable expectation of privacy in that bag. The property
So
concepts.
you're not relying on any concept of temporary here?
No, Your Honor. What I'm relying on is that the government has the burden of proving the relinquishment of that reasonable expectation of privacy.
So let's, kind of along that line, just assume you're the district court judge, you're sitting there, you're listening to this, and here's the evidence the judge had. You have a backpack. There's apparently no name tag or anything else on it. It's left in the middle of the night in a stairwell that's accessible to anybody who wants to come along. There's no claim at any point by the defendant that this is my backpack, you can't get to it. That's what there is. And even though it's the government's burden of proof, what indicia did the district court have that it was your client's backpack and that it was not abandoned?
So I will say, Your Honor, I think both the government and the district court acknowledged it was my client's backpack. Law enforcement saw him walk into the building.
Right, because that placed him there with the crime, but there's no claim or indication of dominion by him over this bag once he drops it.
So I think in order to answer that, to put this in context, when my client walks into the building, goes up the stairwell, no one from law enforcement sees that occur. They see him walk in with the bag. Bag is placed on the floor, goes through the door, and within an extremely short period of time, law enforcement follows him in and tackles him and seizes him. So I don't think that there's frankly not any real objective information whatsoever about the circumstances that lead to the bag being set on the ground. One of the things that I think is most important is looking at this court's abandonment precedent. You really see one of two things, or sometimes both things, in the abandonment cases from this court. The first is you see cases where the bag or other property is abandoned during flight, and the second is express disavowal of ownership. Farabee, there's a clear and unequivocal statement to law enforcement disavowing ownership of the bag. Frazier from this year, defendants fleeing from law enforcement immediately before being apprehended throws a bag 40 feet into a public courtyard. Small in 2019, a defendant in headlong flight from law enforcement crashes a vehicle, tosses his clothing and cell phone while fleeing from law enforcement. Stevenson, there is a letter from a defendant who signs the letter, former tenant, and says, I am turning over all personal property in my apartment to my ex-girlfriend. And LeShook from 1995, the officers testified that the defendant expressly denied ownership in the property in that case. I have not found a published opinion of the Fourth Circuit where flight or express disavowal is not present. And it's not disputed that neither of those things are present in this case.
To agree with you, wouldn't we have to find the district court clearly erred in finding abandonment, and how do we get there?
Sure. So the clearly erroneous legal error issue is a little bit unclear in terms of the case law. I think that it's my understanding of the standard of review is that the factual findings are certainly subject to clear error review, the factual findings underlying the reasonable expectation of privacy analysis. But the reasonable expectation of privacy analysis itself is a legal question.
So you're saying it's a mixed question of law and fact?
That's what the cases have fairly uniformly said. And I think why...
So what is clearly erroneous then, from your perspective?
Sure. I think one thing that is particularly clearly erroneous in terms of factual findings is the references to Mr. Mayberry's post-arrest statements. So the magistrate report,
I'm sorry,
Sure.
it's just sort of almost like a fact question. I'm trying to understand the case. I don't understand why you want those statements out. Those statements actually seem to me to be the only time when your client intimates, at least, I wasn't abandoning anything. I didn't want to get robbed, so I left the drugs outside the door on the stairwell, and then after I got the money, I would go back and get them.
so I don't mind the statements that that was my bag and that those were my items. The problem with the robbed statement is there's nothing in the testimony that he said that to law enforcement in an interview after being arrested. Where that comes up is 2 years later.
No, I understand that. I guess I'm just saying, from my perspective, it seemed like, I mean, I agree with you that those statements don't come in, so it doesn't really matter, but they seem like, those statements were what helped me to construct a reason why someone might have dropped the bag in the stairwell without abandoning it. I just don't want to get robbed in the hotel room, and as soon as I get my money, I'm going back for the bag.
I think certainly in hindsight, it can put it in context, but because it's not an objective fact that's known at the time to the officers, I think that the way I view this is there's really not enough objective facts or actions to draw any inferences based on the information known to law enforcement about why the bag was set on the ground. It's a very brief period of time. I do want to touch on the Plainview issue. The government raises Plainview as an alternative sustaining ground on appeal, not argued below. The only issue, I think, the only disputed element is the immediately apparent element. I think that what this court's cases say is that everyday objects whose predominant purpose are not criminal can only be seized if there's an additional evidence.
Seized, it's an exception to the rule that you need a warrant for a seizure, but the police searched the
Correct.
backpack. They opened it up, they saw what was inside. You can't do that under the Plainview exception.
That's right, Your Honor. And this year, the Davis case from this year draws the distinction between seizing an object or seizing a container and searching it. And so I agree. Even if Plainview were to apply, it gets the bag. It does not get into the
It
bag
might
without
allow
a
them to
warrant.
seize it and bring it to the parking lot without a warrant.
Correct.
Right.
Correct. I think they probably could do that under place regardless. But in terms of the seizure, the government argues in the brief that the officers took extensive investigatory measures, which they developed probable cause, tying my client to the crime. I just don't think the record supports that in any way.
Well, what about the texting that occurred with Davis?
The record indicates that Davis, or law enforcement using Davis's phone, receives a text from a number believed to be associated with the Phillips, the other individual, that he was arriving at the hotel and needed to be let in. The problem with the government's argument is that's essentially the only thing that ties, I see I'm out of time, if I can briefly conclude. The only thing that ties my client is the proximity to arriving when that text message arrives.
And then he got another text message telling him, come on in, where to go, which he got out of the truck right after that. Maybe that's a coincidence. Goes into the hotel, follows the directions, maybe that's a coincidence. But
So
it seems like there's more to it than you've indicated.
there is, I think it's a fair characterization to say there is more to it than purely driving into a parking lot at the same time. But there's no evidence in the record that ties any specific action, any specific characteristic about Mr. Mayberry or his truck. He's walking into a hotel with a bag and a young child in the middle of the day, and I don't think that's sufficient.
Does that answer your question? Okay, thank you very much. You've got some rebuttal time.
Thank you.
Mr. Sachs.
May it please the court, Ethan Sachs on behalf of the United States. I'd like to start with the abandonment issue that we've been discussing this morning. I think it would help to clarify what this court has laid out as the standard for abandonment. The most recent case is United States versus Small, but it has said so, used this description on multiple occasions. And Small is 944 F. 3rd 490 at 502. Quote, abandonment is based on whether the complaining party retains a reasonable expectation of privacy in the articles alleged to be abandoned. Our brief cites on pages 21 to 22 a strong line of cases from multiple circuits around the country where a suspect or a person who leaves an item in a commonly accessible public area and the item is unattended, that person has no reasonable expectation of privacy in that item. So for example, we have Dickens, a Third Circuit case. A person leaves an item in a common staircase of an apartment building. We have Arboleda, the judge-friendly opinion from the Second Circuit. The person leaves an item on the fire escape of a building. There are others that we don't have in our brief that I'm happy to provide to the court if it'd be helpful, but they involve a cooler put on a breezeway of an apartment building that's commonly accessible to the public. And I think
There's no, people can't rely on any kind of sort of societal norm. Like I put my suitcase in one place and I'm just like so fast and I like dart over there and grab something. Like, can't I sort of assume that other airline passengers are unlikely to seize the moment to open my bag and see what's inside?
I do think it's fair to consider the context surrounding the departure or the leaving of the bag or item somewhere. So for, just another hypothetical, if someone left a bag on their table at a cafe, say, and went up to the front to get another cup of coffee and left their effects there, their phone, other things that indicated that that's their bag and hasn't been left unattended, I think in those circumstances, perhaps they have a reasonable expectation of privacy, but that's very far and different from what we have here. And I think here we have a stairwell of a hotel that people, guests, members of the public, really anyone can walk in and up and do walk in and up. And not just that, but the door is closed. So Mr. Mayberry closes the door and walks out into the hallway and walks, the record shows, about 15 to 20 feet down the hallway with no indication of returning. So those facts, which again are reviewed for clear error as we've discussed this morning, I think leave really no doubt that he left the bag unattended. I grant.
What would happen, let's say he drops the bag, goes out the door closes, you're walking down the hall, and he's suspicious something's not right, and he turns around. He's walking back to the stairwell. What would happen then?
So that's a harder case for us, but I still think it may be that there's no reasonable expectation of privacy in a bag that is left in this public, commonly accessible area. It may be that that would reveal that Mr. Mayberry subjectively expected to go back and grab the bag, but I think the key question is whether that's reasonable.
So are you asking us, I understand your point about the overlap between the abandonment doctrine and reasonable expectations of privacy, but are you suggesting we just take the intent question out of it? Because I think we've also said several times it's all about whether this person intended to abandon the item.
So we would
Look at objective indicia of that, but that's the bottom line question.
Yes, we're not disputing that. I think Small puts it helpfully to say to determine whether the defendant maintains a reasonable expectation of privacy in an item, the court performs an objective analysis which considers the defendant's actions and intentions.
So can I ask you a question
Sure.
about intent? So we have a lot of cases where the government sets up a controlled buy and then arrests the seller, and then the drugs are found some distance away, like around the corner in an alley or something like that. And so the defendant says, those aren't my drugs. And the police officers pretty consistently come to court and say, in my extensive experience, this is just how people set up the drug deals. They don't want to be robbed while they're making the exchange, so they put the drugs some distance away and then they go get them. So did the police officers in this case not have that experience? Why didn't this just look to them like a classic case? He's not abandoning anything. He's going to get the money, and then he'll get the drugs.
So two things in response. I don't think the record is perfectly clear on what the officers hear, what their experience was, but I have no reason to suspect that they didn't have that
Okay. So why didn't
experience.
this just look to them like, obviously, he doesn't intend to, this is just our standard case. He hasn't abandoned anything. He's just safekeeping during
Sure.
the deal.
So I think it's important to here clarify that this is also small, and I think it gets at this issue. Abandonment is not based on whether all formal property rights have been relinquished. And so I think the intent really goes to the formal property rights. I think the defendant, or the hypothetical defendant in that circumstance, leaves the drugs in an area, the alley, I think was Your Honor's question. It is still their own, they own that property. We don't dispute that. And they may have an expectation of going back to that property. But I think what the cases say is when it's a common, publicly accessible area, that's not a reasonable expectation of privacy.
So it can be both the case, right, that those drugs in the alley are abandoned, but also attributable to the defendant?
That's correct. And I think that's, frankly, the perhaps most difficult part of understanding, at least for me, abandonment, because it's really the distinction between abandonment not being based on whether all formal property rights have been relinquished, but really the expectation of privacy, whether they the person whose bag it is retains a reasonable expectation of property in that, privacy in that, excuse me. And so a couple other things I'd like to emphasize is, just to clarify from...
So is the sort of the bottom line of your argument that in this circumstance, if you leave the bag in a publicly accessible place like that, and there's some separation by the closing of the door and that sort of thing, that is an unreasonable expectation of privacy by the suspect?
Yes, I think under the facts of here, undoubtedly, it's unreasonable.
So you're saying intent to return doesn't matter?
Well,
If there is sufficient evidence that you have abandoned any reasonable expectation of privacy, because it seems to me that it's pretty clear they can coexist. You can intend to return, but yet still abandon reasonable expectation of privacy.
So I think, I understand Your Honor's point, and I think it's actually very helpful to read Arboleda, the Second Circuit case I mentioned, and the site of that is 633 F. 2nd 985. And Judge Friendly there says expressly that it is irrelevant that the person whose property is may later intend to return and pick up that property. And I think what the best reading of that is it's irrelevant for abandonment purposes, but it's not irrelevant, as I was discussing earlier, for ownership claim or other property-related rights, which are separate from abandonment.
So you can see we're sort of casting around to make sure the principle is narrow enough. So here's another hypothetical. The defendant leaves the bag, it's in the stairwell, goes out the door closes, and he's going down the hall, and the child says, "Dad, you left your bag in the stairwell." And he says, "Yes, I'm going to go back and get it." And the police officers hear that. What happens then?
Again, Your Honor, I think that is a harder case for us, and I will grant you that I don't think that intent is totally irrelevant, but I do still think that that would be abandonment. I do still think that it's an unreasonable expectation of privacy for someone to leave their bag in a commonly accessible public staircase. I mean, I think, I don't want to fight the hypothetical, but assuming that the door is closed and that Mr. Mayberry has walked away and all that's different is the child says something, he responds, I still think that would be abandonment. But, I don't think the court needs to go so far in making a very broad rule. I think if it would like, it could, say, because it's clear error, and the case to support that is Farabee. Abandonment is a finding, that is a fact that is reviewed for clear error. It could say, and we'd be happy with the court saying, in these circumstances, with these facts, it was not clearly erroneous for the district court to reach a finding of abandonment. And I agree that there may be some cases at the borderlines where we could imagine hypotheticals where it's difficult to determine whether the expectation of privacy is reasonable, but I don't think this case is one of them.
Well, what about the issue of the mixed, is this a mixed question of fact and law? I mean, I don't think we've really been clear. We've said that abandonment is a fact call.
Yeah, that's
subject to a clear error analysis, but there is an overlying, I guess I should say, component of reasonable expectation of privacy. And that's, are you saying that's purely factual as well?
I think the best reading is that it's purely factual in the context of abandonment, because I think it's really a sort of the same determination of abandonment. So the best reading of Farabee, I think, is that it is a questioning of fact, a finding of fact that's reviewed for clear error. I don't think it's outcome determinative here. I think under any standard of review, the district court's decision was sound. But I
I'm
do
just
think,
wondering, do we need to spell that out in this case, from your perspective?
I don't think it's necessary to do so. We don't oppose the court doing that. I think no matter what standard of review applies, I think the court could assume any standard of review applies, and I think we would still say the district court's conclusion was more than sound in these circumstances. I just wanted to clarify one further thing about the record in this case, about what the district court held as opposed to abandonment. And the key pages of the record are JA 347 and 348. And I think reading that makes it very clear that this issue about considering statements after the fact or considering statements, the silence, post-arrest silence of Mr. Mayberry, really didn't go to the heart of the abandonment analysis. If I could just quote briefly, the court says, quote, "It agrees with the analysis and conclusions of the magistrate judge that Mayberry intentionally abandoned the backpack when he left it in the closed common stairwell, exited the stairwell into the second floor hallway, and walked 15 to 20 feet away from it with no indication of an intent to return." And then there's a new paragraph that says, "Mayberry next objects by way of rhetorical arguments that he's not required to make a claim of ownership and that the court improperly considered statements that he made later on." So I think that's clear from that lineup that it's not, those factors aren't going to the abandonment analysis, but I also don't think it would have been improper for the court to consider his post-arrest silence. The Supreme Court has been clear that a defendant's post-arrest but pre-Miranda silence, which is what we have here, can be considered as evidence of guilt. And if we think it can be evidence of guilt, then certainly it can go towards a finding of abandonment.
I'm sorry, so we're talking about the failure to claim ownership?
Yes.
Okay, and what is your position on it? Your first position is the district court didn't really rely on it.
Right.
But I just want to make sure I understand your position about the relevance of the failure to.
Sure.
Yeah.
That it was not improper. We don't think it, in fact, the district court did rely on it. But had it done so, we don't think if making it a requirement may be a problem. But considering it as one factor of a constellation of many is not inappropriate. And as Your Honor's questions earlier with my colleague, I think, got at, well, of course, if he claims ownership of it, that would be relevant. So the inverse must be relevant too, his silence. But I think what's helpful to think about there is the Supreme Court's description and holding that a defendant's post-arrest but pre-Miranda silence can be considered as evidence of guilt. We think, well, if it can be considered as evidence of guilt, certainly it can be considered as one of many factors of abandonment.
On your reasonable expectation of privacy, given the emphasis on that, would it even matter if he said, "No, that's my bag"?
No, I don't think so.
Right, you think, like, he could be telling the police officers, "That is my bag, I own it and I want it." Doesn't matter, like he left it unattended.
That's correct. We would think it still would be abandonment.
That's pretty broad.
That is broad, and again, we don't think that it has to, it may be broad. We don't think it's particularly broad. We think it's in line with the cases that have.
It is hard to reconcile. I'm just trying to think about kind of writing it.
Sure.
Like, yes, the key question is the intent of the defendant. The defendant says to the officers, "Here is my intent. That's my bag. I want it. I own it. It's mine." But he's abandoned. That just seems weird.
I would just emphasize that that's really not what we have in the facts
No,
of this
but
case.
it is your argument that it doesn't matter. You left something in public, anyone could have opened it.
Yes, I think that is I think that's correct, and we really take that from the line of cases I mentioned before that say that there's no reasonable expectation of privacy in property left in those sorts of areas. I'd just like to briefly touch on the probable cause. I think we've gone over it to arrest Mr. Mayberry. I think we've gone over it pretty clearly so far, but this is really, I think, a case in which the police took the extra steps that this court has instructed it to corroborate a tip and confirm the tip. And it's not just the text message sent from Davis's phone to ended up being Mr. Mayberry, and hearing his response that he's arrived, but also, as Your Honor indicated earlier, that he went up to the second floor exactly at that moment that he was instructed to by Davis's phone, who he thought was Davis. If Your Honors have no questions on that, we would rest on our brief and ask that you affirm.
Thank you very much,
Thank you.
Mr. Sachs. Mr. Warren, you've got some rebuttal time.
Thank you, Your Honor. A couple brief points. Judge Keenan, I think to answer your question about the standard of review, and I apologize, this case is not cited in my brief, United States versus Stevenson, and it's 396 F. 3rd 538. It's a 2005 case written by Judge Niemeyer, I think has the clearest explanation of the way the standard of review works in an abandonment case.
Yes, Stevenson is quoted in Farabee
Correct.
for that proposition.
That's right, Your Honor. And that was Stevenson was a real property case, and so there's kind of a more extensive property right analysis towards the end, but it does say it's a mixed question. Fundamentally, the problem in this case is when law enforcement arrived, Farabee, Small, all of this court's cases say that the analysis of abandonment turns solely on the objective facts available to the officers of the words and actions. Here, I think to put this in context, law enforcement has no idea who Mayberry is.
I'm sorry, can I just, just when you said the standard, it turns on the objective facts in context of what? What is the underlying question that we're supposed to be asking?
Did the defendant manifest a relinquishment of his reasonable expectation of privacy in a piece of property? Whenever this court addresses that issue, it typically comes up again in the context of flight or disavowal. And the vast majority of cases, there is some clear, or actually all cases, there is some clear evidence of the defendant doing or saying something that relinquishes his or her expectation of privacy. Artileta, the Second Circuit case cited by my friend on the other side, the defendant hears law enforcement coming to a house, hears a knock on the door, throws a bag of cocaine out the
How do
window.
we know that in this case he didn't get kind of suspicious? Like there's the stakeout in the parking lot. I mean, it seems entirely plausible that he realized something was up.
It's plausible. Equally plausible is he's walking with a young child inside and has to pick the child up and open the door. We just don't know. And I think the most pertinent point about that is the government has the burden of demonstrating objective facts in words, objective facts of words or actions. And this case is really unlike any other abandonment case I've ever seen because law enforcement doesn't witness the acts of alleged abandonment here, or the defendant does not disavow or take some action in front of law enforcement.
So, I'm sorry, you're saying if there had been a police officer at the bottom of this stairwell who saw him put the bag down, that would be a different case?
I think that would be a different case in the sense of a law enforcement officer would be able to testify about the circumstances that lead to the bag being set
He
down.
walked in with the bag and he walked out without it. Like, I mean, so are you saying that leaves open the possibility that, I don't know what, someone swooped in and grabbed the bag? And I don't understand, if you know he walked into the stairwell with the bag and out of the stairwell without it, what more could my hypothetical officer on the ground floor add to the equation?
I mean, I think it depends obviously on the situation, but that officer would be able to provide information about the circumstances of the bag getting on the ground.
How can we not, pretty much to a certainty infer that he put the bag down before he walked out the door?
Well, I don't think there's any question.
Okay.
I think we can infer that.
Okay.
What I mean is that in that circumstance where an officer sees that, there may be some circumstantial evidence of why the bag was put down or what behavior he was exhibiting when he put the bag down. I agree. There's no question. He walks into the stairwell with the bag, sets the bag on the ground at some point, and goes out into the hallway. I think the example that was asked of counsel for the government about the cafe and the person who leaves food on the table or leaves possessions on the table, a cell phone, a wallet, any other number of personal possessions. As I understand it, where the government draws the line in this case is if law enforcement were to go to the cafe and the defendant or the person in question was not at the table or perhaps had left the cafe to go to the restroom, law enforcement would be able to claim that those items had been abandoned, despite having no information about the circumstances under which the person at issue.
I didn't understand Mr. Sachs to take quite that position.
I think that is how I understand the government's argument, is that my client had the bag, left the bag on the other side of a door, and walks out of the stairwell. And that is evidence of, or that is abandonment. That is the way I understand the government's argument. And I think where that is problematic is the government engages in what the Drakeford court said that law enforcement or the government can't do, which is labeling the defendant as a drug dealer and viewing the actions through that lens. This court has said that's not how we analyze Fourth Amendment issues. Unless the court has any questions?
You did have a third issue on withdrawal of the guilty plea, which you didn't address in opening argument. Is there anything other than what's in your brief?
I'm happy to rest on my brief unless the court has any questions.
Well, thank you very much.
Thank you.
We appreciate the argument of both counsel, but Mr. Warren, we want to know that you're court appointed, and the court appreciation to you for undertaking that activity, because without members of the bar like you who will step up and undertake these cases, we could not accurately and dispassionately dispense justice. So we will come down and greet counsel and move on to our last case. Please be seated. All right, our next case is United States versus Nashley. Mr. Miller, been a while. Be glad to hear from you today.
Thank you. If it please the court, I'm Morgan Miller on behalf of Ms. Nashley, and this is an interesting case. At the beginning, before trial commenced at a hearing with the court, the defense said they wanted to present evidence that she was an abused woman, and because of that situation, she did not ask whether there were employees in the loan that was the subject of the case. Count one was a conspiracy to get a payroll protection loan for two different companies that her husband had founded. And it was alleged that what she did was prepare the payroll spreadsheets that were used to accompany the loan application. And the allegation was that she knew that in the spreadsheets there were no employees when she said, these are the employees and these are the amounts. And the defense was that, well, she didn't know whether there were employees or not, and she didn't ask. And the reason she didn't know and the reason she didn't ask was because she was an abused woman.
Okay, now, the evidence in the record, though, that you were pointing out to, or not you, trial counsel was pointing out to the court, Mr. Miller, was the August 2020 conversation with her husband's daughter. Isn't that correct?
That was part of it, yes. The other
Okay.
part,
And that occurred like 3.5 months after these events in question. So did you present, or did counsel for the defendant present to the court any contemporaneous evidence or evidence prior to the acts in question that she was acting under compulsion from her husband?
no, and what he wanted to do was to have her testify. And the judge said that
Have who testify?
the defendant. The judge said the defendant may testify that I was compelled, and that's it. And the defense lawyer said, well, look, we want her to say, I didn't know, and I didn't ask, and why, and explain why. And the judge said, you can't do that. If she mentions anything at all about that, that's not going to be allowed. No abuse, no beatings, no psychological effects at all.
I thought the whole basis of that was that the defense counsel at trial said, look, we're not going to put on a duress defense. Absolutely not. We're not going to do that.
That's
But
correct.
it had the appearance of putting on a lot of a defendant's duress evidence, but either not having to meet the elements of duress, or, for instance, with the email that Judge Keenan referenced, getting the defendant's statements into the record, but without ever subjecting her to cross-examination.
No, the defense was told by the judge she may not testify about abuse or physical abuse or anything like that. And it was not a duress offense. Duress says, I committed the crime, and I was compelled to commit the crime because if I didn't, I was going to be killed. I was going to be maimed, serious immediate bodily injury right then and there. The defense said, we're not doing that because and JA 101, 102, we would have to admit. We're not admitting. She didn't know. And she didn't know because she was abused. And that's different than duress. That's a defense that goes to mens rea and negates it. It's not an affirmative defense. It's not immediate harm. All through their brief, they say threats of abuse in the context of right now, right now, right now. There was no dispute that battered women who are abused have physical and psychological abuse. It leads them to be in a sense of helplessness and passiveness and obedience that's not questioned.
Well, and what evidence was there in the record, though, that she was this type of, or was suffering from this kind of abuse, other than the August 2020 conversation that we previously mentioned?
There was that tape, which was, she didn't know she was being recorded. If you hear it, she sounds emotional. And it's the description of a present emotional sense under 8033 would be admissible, also under 807, because she didn't know it and she's talking to someone about events in the past. And the fact is that she was talking about, in that conversation, what was going on when the loans were going forward. And
This is the August conversation.
the August conversation, the secret tape recording. And that was a sufficient basis for the defense lawyer to say, we want her to testify. And the testimony would have been along those lines. But the judge says she cannot testify. I'm not going to let her take the stand and explain why she didn't ask. And she's entitled.
Was there ever a proffer from defense counsel? I know there was a lot of discussion. We want her to testify and say she was abused and this, that, and the other. But do they ever make a proffer of, if she testifies, she's going to testify that this, and this happened?
It was not put in that way. However, it was in the record because it was what was on the tape, and the defense lawyer wanted the jury to hear the tape. And the tape would have been either, if it was admissible, the judge could have said, well, after she testifies, you can put it in. And it was clear that those facts in that tape, which were known to the defense, the prosecutor, and the judge, were evidence of abuse And if she was going to testify, it would be logical and consistent with the presentation of the defense intent of establishing abuse, that's the lines about which her testimony would follow. Excuse me, not about which, those were the lines her testimony would follow. And so it was clear, and no one was questioning the nature of what her testimony would be. Everybody, because the prosecutor said, well, if she testifies to abuse, it's going to be prejudicial. And if she testifies to abuse, and people understand what abuse is and how it works, is psychological and physical. And the court said, yes, it's prejudicial and it's not relevant. Well, it is relevant because, and there was no question about what the testimony would be because we have an outline of the abuse. 90% of the time he berates me, he shoves me, he slaps me, he hits me, he's threatened to tear out my stomach.
Well,
that's the nature of the testimony.
What's your best case where there's not a duress defense and the evidence is not offered in mitigation and sentencing, but it's offered as part of the defendant's case in chief to negate mens rea, but it's not a duress defense?
The closest is the Merengue case from Maine, but I will venture so far as to say that there are not a bunch of cases out there where this issue has come forward. But the sentencing cases like Johnson in 91 were 30-some years ago. The law says, and you have said, that in Queen, that relevance, which is a basis to exclude, that relevance, under in quoting Wigmore, is such that if it has any tendency to prove something that's in issue, it's relevant. It doesn't have to be the bombshell that's going to bust the case wide open.
Can I ask you a question? I feel like if I had been the judge, just a minute or two ago, you were sort of outlining the abuse, threw me down the stairs, hit me, threatened to cut out my stomach. I would be concerned about jury confusion, even if there was some minimal relevance here. It seems like, I mean, even conceptually, it is hard to sort of separate out the duress defense from allegations like that. And it just seems like the jury would be hard-pressed not to think that what it was supposed to decide was she too scared to say no?
It's not that you're scared.
Well, I understand that,
It's
but
that
my
you're
concern would be
complacent.
that the jury would think that that was the question in front of it, that they would think they had a duress defense case, basically.
If she was allowed to testify and present the evidence, and if the lawyer was allowed to argue it, there would also have been an instruction.
Yeah.
And so
And I
the
guess
jury
the
would
other
have
thing that-
known that it's not duress, that it's abuse, and what they are
It goes to mens
considering
rea, but Can I
fine.
just finish this one thought? The other thing that makes me worried about it is that it seemed to me you wanted to, or the idea was to introduce this evidence because it would explain why the defendant didn't ask questions, right?
Correct.
Why she didn't know. But this didn't seem like it was being tried as a case about what the defendant didn't know and why didn't she ask questions. It wasn't about willful blindness. The evidence put the defendant like right smack in the middle of all of these events. I mean, those texts, it's not that she didn't know, she's writing the texts about how we're going to pull this off.
The texts were about the loan, not about the payroll thing itself. She got advice from Kobe, the banker, about the payroll, and she exaggerated some of it. The whole case was whether or not she knew, and that was the issue. And they didn't, I'm sorry?
She kept texting or emailing her husband about, this is what I'm doing, this is how I'm going to do it. Are you sure you want to go through with this? And I think there's one exchange where he says, if you're not comfortable with this, leave it. But the government has a fair amount of evidence from the ADP consultant, the auditor, the court-appointed custodian for the airline company that really, as Judge Harris puts it, well, she's right there in the middle of it, if not the creator of it.
I mean, wasn't there also evidence where she told her husband, this, this isn't the IRS, this is the SBA, suggesting.
She's, and you could say that suggests that. You could also say that it suggests that here's a brand-new program, it never existed before, there's never been anything like it, let's try it because it's a different deal. And you have the inferences that can go that way. And if she was allowed to defend herself and testify about abuse and the consequences of it and why she didn't ask, then the jury would decide whether or not the inferences that you're drawing are correct, and there would have been a counter to those inferences. There was no direct evidence she knew. I've never been in a case where the chief cooperator was never on the stand, and he could have said directly, and he didn't. They kept Kobe, the banker, off the stand also, and he knew what he talked with her about. They don't have any idea about conversations they had over the telephone. They don't have all the texts. His phones were in his children's control for months and months and months. Then they were in the lawyer's control. Nobody knows what other texts were on them or not. And if she'd had a chance to say, ladies and gentlemen of the jury, this is what was going on, then A, it was relevant under Queen, and then it would have also have been non-prejudicial, because under Arimony, it would not have excited the jury to what you said in that case, which was irrational behavior. And it wouldn't have prejudiced the husband because he didn't testify. So it would have prejudiced the government. The issue is the jury should have had a chance to consider this. It's admissible because it's relevant. It's admissible because it's not prejudicial. You know what she's going to testify about. She's going to testify consistent with the tape recording, and that she'll be subject to cross-examination. And that's the reason why they have the instruction that is willful blindness, because was she willfully blind, or did she not know for a reason? And she should have had the chance to tell the jury that she didn't know and what the reason was, and the judge said no. He was wrong on relevance and wrong on prejudice.
Mr. Miller, are you
Mr. Miller, hold on a second.
going to talk about the jury instruction,
Very briefly, Your Honor.
or in your rebuttal, or
I'll do that in my rebuttal.
I guess you need to briefly mention it here to talk about.
I do
your
intend,
rebuttal.
very briefly, instruction on 4 and 5 tied them to count 1, the conspiracy, in count 1, 11 through 18, or how to get the loan. 21 is spending the money, doesn't mention the loans. The loan does mention transfers in 4 and 5. The transfers in 4 and 5 are not said to be part of the conspiracy. They're just simple transfers of money. And so it's not spending from the conspiracy. It's not getting the loan from the conspiracy. And the tying them to the conspiracy
I
was
just have one
erroneous.
quick question. How did
Yes.
the erroneous instruction get into the record? Who put it in? Or do you know?
I don't know who submitted it. I know that the judge gave it. I'm not sure that it was consistent with the instructions from the prosecution. I know they did not come from the defense.
Okay.
And there was no objection.
And it's clearly erroneous because, as you said in Hutchinson and Pavlicek, if there's no proper instruction on what the jury has to find, you never sustain a conviction. And in Pavlicek, it was the jury accepting overt acts outside the statute of limitations or inside? We don't know because it was a general verdict. Here we don't know whether they were looking to tie this to count 1, which, as you said, is critical because if it's not a proper instruction, you can't sustain the conviction. So that makes it fundamental, and I know that gets it past plain error.
All right, thank you very much.
Thank you.
Mr. Harvey?
Good morning, Your Honor. May it please the court, Jordan Harvey for the government. I'd like to first address the evidentiary ruling made by the district court, and I'd like to pick up on the panel's questions regarding what allegations of abuse were even at issue. This entire motion in limine made by the government, which was approved by the district judge, was based on the allegations made in that August 2020 tape, 3.5 to 4 months after the events of the fraud scheme. This was not an abuse of discretion by the judge. Rather, this was a decision that the judge made based on what the defense of the appellant actually was. The defense put forward by the appellant was that she was in a relationship that did not allow her to understand what was going on. I think as Mr. Miller mentioned, and as we mentioned in our brief, the opening statement, the closing argument was about she was under the influence of this individual, that she did whatever he wanted because she had just lost her first husband when she met him. And I think defense counsel at trial said that she was in a frenzied, manic mental state. That was the core and the foundation of her defense. And as part of that defense, they wanted to reference, oh, and also this tape from 4 months after all of these events. And I think to the panel's questions to Mr. Miller, this gets at the district judge's decision, an evidentiary ruling regarding the relevance determination that was made. When the judge made this decision on page 101 of the joint appendix, the judge said that in the absence of a duress defense, any mention of this type of abuse is, quote, inherently prejudicial, particularly if the probative value is of no real significance, end quote. So there was a relevance determination that because she said, I'm definitely not putting forth a duress defense, I'm not asking for a justification of duress, a jury instruction, the relevance, the probative value and the relevance was minimal. And then on top of that, I think Mr. Miller stated that if something is relevant, if it has any tendency to prove an issue in the case, but the admitting of evidence does not begin and end with relevance. It must give way to other rules of evidence, such as Rule 403. And the judge not only determined that it was irrelevant, but also under the 403 factors that it was more prejudicial than probative.
Well, there was a lot of discussion back and forth with the trial judge about we want her to testify. She'll testify that she was coerced and that she felt compelled to do this. But I think Mr. Miller acknowledged that there wasn't a specific proffer of, you let her testify, here are the things she's going to testify to, because you've got these concepts of coercion or abuse, if you want, but there's nothing that connects it, so it would make it difficult to rule on the argument that I want my client to testify about these topics without knowing a little bit about, well, what exactly is this defendant wanting to say? So is it your understanding of the record that there is no proffer, per se, of the defendant's proposed testimony?
That's exactly right, Your Honor. Pages 98 through 104 of the joint appendix go through that entire discussion that you just referenced, and I would agree there is no specific proffer of what allegations there would be of abuse and whether they occurred during the time of this fraud scheme and what effect it had on the fraud scheme. None of that was proffered, none of that was there, and that was part of the judge's relevance determination. I think for those reasons, the judge's determination, I also want to mention what the judge did allow her to present, which was everything about the fact that she was compelled, the fact that she was under the influence of this individual, everything I was sort of mentioning before about her sort of compromised mental state because of the death of her first husband, and that was explicitly permitted by the district judge. They talked about that in opening, in closing, even allowed her sister to come in and testify and sort of tearfully tell a story about what her sister was like and that she left the family to go on this trip at Christmas. I think the district court did not make an arbitrary or irrational ruling, which of course is the standard for an abuse of discretion, and just sort of out of hand rejecting her entire defense. The district court permitted what was the core and the foundation of her defense and merely excised the portion about this references in this tape about abuse from 4 months after because they were irrelevant in the absence of a duress defense and because they were more prejudicial than probative under 403. For those reasons, this was not an abuse of discretion. Even if this panel were to find that there was an abuse of discretion, harmlessness review would be the next step. In order for the appellant to succeed on this claim, the court must also find that the error was not harmless. That would require the court to assess the effect of the error in the light of all the other evidence. And I believe, as the panel was just mentioning before, when Mr. Miller was here, there's an overwhelming amount of evidence of her direct knowledge and active, assertive, enthusiastic participation in this scheme. Pages 22 through 45 of our brief sort of comprehensively or exhaustively list all of the different ways that the government proved that she was not sort of an unwitting or sort of following blindly and just doing whatever she was told, that, as Your Honor mentioned, she was explicitly told, hey, if you don't want to do this, then just leave it. You can judge for yourself. And she said, it's a go. I'm convinced. Do you feel okay with it? Right? That there's these back and forth conversations. She's explaining very clearly all the ways in which she is taking the initiative to create these false payroll reports, that she is manually having to figure out the taxes that would appear in a payroll report. Clearly, she knew that these reports she was creating were not legitimate. Why else would a person need to manually figure out the taxes for payroll and things like that? I also think that the documents that she submitted, separate and apart from her work with these companies, that when she submitted documents to other banks for loans that they were trying to receive, those documents on 3 separate occasions contained the correct information, that these companies started in mid-December of 2019, that they were essentially shells for the tax year of 2019, that they had no revenue, that they had no employees. They submitted these because, she submitted these documents, including one document only a week before she submitted the false payroll reports, because they were seeking loans, and the banks were saying, oh, you have this business, did you file any taxes for 2019? And she submitted these documents on 3 different occasions, including, of course, 1 week before she submitted the PPP loans, saying, oh, we didn't have to submit any taxes in 2019 because the business didn't operate until December of 2019, had no revenue, had generated no income, had no employees. And then a week later, files with Bank of America, spreadsheets with 50 employees, claiming that they paid these employees all these millions of dollars, and for that reason they needed $2.5 million in PPP loans. The list goes on, and I know that the court has read the record, but pages 22 through 45 of our brief sort of lay out comprehensively all of the different ways in which, even if there was an error, even if there was an abuse of discretion here, that it was harmless, that it did not have an effect, that even if she had been able to talk about this abuse on this tape from 4 months later, it would not have had an outcome. It would not have had an effect on the outcome of the case. If there are no questions on the first issue, I'll turn to the second issue of the jury instruction. Okay. The jury instruction issue relates to...
Was this a pattern jury instruction?
This was a jury instruction.
It seems a little out of the norm.
So this instruction came directly from the O'Malley instruction manual, the O'Malley, Grenig, and Lee, and is common in conspiracy cases where various co-conspirators engaged in different conduct. And so this was not something that the government or the AUSAs on this case sort of wrote themselves. It was taken directly from the O'Malley sort of pattern jury
You're saying
instructions.
the government offered the instruction?
The government did offer this instruction. The defense did not offer a competing instruction. Rather, they said that this instruction was not necessary. They didn't argue, essentially, they didn't make any of the arguments they're making now on appeal, and that's why we argue that it was forfeited. But
I don't think it was forfeited here, but would the plain error apply?
Plain error, exactly.
Knowledge, plain error would apply here, so you need to address why it's not. Is it error, and if so, is it plain?
Yes, Your Honor. I think the objection by the defense at trial was that this was unnecessary because all the principles covered here were also covered in the aiding and abetting instruction. So that was the objection below, which is, of course, different than what they're arguing on appeal, which is why plain error review applies. On plain error review, it is the defendant rather than the government that bears the burden of proof, and that they must show that if there was an error, that the error affected her substantial rights, meaning that it affected the outcome of the district court proceedings. The appellant has not shown that, cannot show that. By giving this instruction, the district court committed a clear and obvious error. This court, and I don't believe we referenced this case in our brief, but this court in U.S. v. Ashley discusses instructions of this type in other cases and states that a defendant is liable for substantive offenses committed by a co-conspirator when their commission is reasonably foreseeable and in furtherance of the conspiracy, essentially the Pinkerton liability. And that's what this instruction was.
I'm sorry, I thought, I may not understand, I thought the claim was that that would be fine as to, I can't remember the counts, the bank fraud counts, because that was part of the conspiracy.
Yes.
But that counts 4 and 5 had nothing to do with the conspiracy. They were not charged as part of the conspiracy.
And
Isn't that, I thought, is that the basic problem here, or potential problem, that this count 1 instruction seems to suggest that you could convict based on Pinkerton liability for all of the counts, but in fact, at least it is argued, the counts 4 and 5, the monetary transactions, are not charged as part of the conspiracy.
that's right, that is the appellant's
Okay.
argument.
Okay, so why is that wrong?
Our argument is that the indictment does incorporate, the conspiracy count in the indictment does incorporate counts 4 and 5.
So you, okay, so, and I mean, so I also am trying to figure out what went wrong here. But so basically, you, on the theory that counts 4 and 5 were incorporated into count 1 as part of the conspiracy, you wanted an instruction that reached counts 4 and 5.
That's right, Your Honor.
Okay.
Yes.
All right, I'm looking at count 1 in the appendix. Why don't you give us what you say is the best language that supports your argument about the incorporation of counts 4 and 5?
So I'm on Joint Appendix pages 11 and 12. Count 1 states, it was a further part of the conspiracy.
Which paragraph are you on there?
I'm not sure. I have it
Is this
written here.
21?
I would have to look at, which I don't have with me, and I apologize for that, Your Honor. I don't have it numbered by paragraph.
All right, well, go ahead and read it, we'll find it.
It was a further part of the conspiracy that once, and then I have it in brackets here, once the defendant and her husband obtained the proceeds of the PPP loans, they knowingly spent those proceeds in part on numerous items that they knew were not authorized under the PPP. There's also on Joint Appendix page 28, under the heading of count 1, the nature and purposes of the conspiracy are stated to be, quote, to spend the fraud proceeds on items that were not authorized under the PPP. And so this, I think, is probably the best language to show that.
Well, I'm looking at the nature and purposes of the conspiracy, which would be paragraph 11. It says the purpose and object was to obtain monies. Yeah, okay, I see where it says to spend. All right.
And so I think that's sort of the best language. And I can see, Judge Harris, that it could be clear, but I think that our position is that this incorporates not only the receiving the money, but also, and sort of understandably, spending the money, transferring the money, that a conspiracy to fraudulently obtain monies sort of has no purpose if you're not going to then transfer and spend those money.
Miller's argument on the brief to be there's a difference between spending and transferring.
I did see that, Your Honor. I think that these were charged as 1957 counts, which is any transaction of $10,000 or more. And so I think it could be if someone spent, purchased an item that was $10,000 or more, that could constitute it. Here, they were transfers of bank transfers from one bank account to another.
Can I ask you something I found just confusing about this instruction issue? In your brief, you also argue in the alternative, if they're not incorporated, well, the instruction on counts 4 or 5 says specifically it has to be the defendant's own conduct. So both things can't be right? Like if in fact it was incorporated into count 1, then the instructions on 4 and 5 are incorrect, right? Because they say it does have to be the defendant's own conduct. You can't rely on Pinkerton liability. So I'm just having trouble figuring out how your arguments fit together.
Yes, Your Honor, I think it's two ways of proving the same thing that.
But they're two inconsistent ways, and that's what I don't understand. If you thought count 1 was incorporated, if you thought count 1 incorporated the transfer offenses under counts 4 and 5, why did you want a jury instruction for counts 4 and 5 that, on your own account, says you can't use Pinkerton liability, it has to be her own conduct?
I think that if the jury believed beyond a reasonable doubt that she directly engaged in this activity, which was the evidence that we presented in the case that we presented at trial, then that would sort of fall in line with the instructions in 4 and 5. If the jury was not convinced of that, but was convinced that her husband, Kindambu, made those in part and in furtherance of the conspiracy, that then she would also, through Pinkerton liability.
So you asked for these instructions so the jury would have two different ways. But then, so you are not making the argument you made in your brief that because 4 or 5 comes later and is more specific, it sort of clarifies that you can't use Pinkerton liability. We're not arguing that.
I think it's an argument in the alternative, Your Honor. I think it's an argument that there is no.
You're arguing you can't use Pinkerton liability under counts 4 and 5. I wasn't quite sure what you were saying there.
I think, Your Honor, the argument, as Judge Harris said, I think there is, if the jury finds that she directly engaged in these activities, that sort of goes to the instructions in 4 and 5, and that the fact that it was also incorporated into count 1, the conspiracy, would allow her to also be convicted under Pinkerton liability. And so I think these instructions, as sort of read together, allow for both avenues for the jury to find that she was guilty of counts 4 and 5.
But you are no longer arguing that, no, the jury could only have understood that for a conviction on count 4 and 5, it had to be her own conduct. Because that's what you say in the brief, that like you have to assume the jury followed that instruction. But this is a slightly different argument that.
I think it's an argument in the alternative. I think the primary argument is it is incorporated in count 1, therefore there is no plain error. I think if this panel finds that it wasn't incorporated in count 1 and there is plain error, we get to the question of whether there was a substantial effect on her rights, because she could only have been found guilty if she had directly engaged in that. And so I think in that scenario, we say, well, it didn't have a substantial effect because the jury, very easily could have found that she directly engaged in this. So I understand the court's question. I hope that makes sense.
So it goes more to we can't say on plain error review that the jury necessarily convicted her on a Pinkerton theory for counts 4 and 5.
That's right, Your Honor.
Okay, Mr. Harvey, I'd like to mention something before your time runs out. Your brief, I think, is atypical from most of the government briefs that are submitted to us. You have a number of factual assertions that are not supported with JA cites. And what you're essentially doing is making these factual assertions and then saying to the court, you do the work, find it. It's somewhere in there. And I'd like you to, I think it would be appropriate for you to give some thought to that next time you file a brief with this court.
I apologize, Your Honor. I thought that we had cited most of our factual assertions in one place or another, but I will be diligent about that in the future. I apologize.
All right, thank you very much.
Thank you.
Mr. Harvey. Mr. Miller, you have some time left. you don't mind, why don't you start with this jury instruction question, because it is a little perplexing.
Yes, Your Honor. Judge G, the instruction was that if they found that 4 and 5 were committed by a co-conspirator in furtherance of the conspiracy, then she's liable, vicarious conspirator liability.
Under count 1?
On count 1.
4 and 5.
If she was a conspirator in count 1 and a co-conspirator in count 1 committed 4 and 5, she's guilty.
Under count 1.
Under count 1. And count 1 would allow them to convict of count 4 and 5. That's what he said. If you convict of count 1, you can convict of count 2, 3, 4, and 5. And now 2 and 3 were the substantive offenses, and that's correct.
Right in front of me, but I thought that his instruction, which is a little confusing, did say basically the effect, but that you can only convict under 4 and 5 if the government proves each particular element.
Right.
There were two different instructions.
Well, yeah, at JA 871, I think you have a corrected instruction as to the elements that need to be proved.
The judge instructs them.
4 and 5?
No, with the conspiracy.
In the conspiracy, and in the instruction there, he says that if you find the elements and a co-conspirator committed the offense, and she was a member of the conspiracy at the time, then you can find her guilty of 4 and 5, because that's what he says. Later, he gives an instruction on 4 and 5 that have all the correct elements. So the jury has two different instructions about count 4 and 5. And so the question that we have is,
So is that 869 where he says, if you find the government's proven the defendant guilty of conspiracy beyond a reasonable doubt as charged in count 1, you may also find the defendant guilty of the crime alleged in the other count, an indictment which he's charged, provided you find the essential elements of that count have been established by a reasonable doubt.
right, so the essential elements for a co-conspirator by under reasonable doubt, and she's in the conspiracy in count 1, then you can convict her of the substantive offenses. That's true for 2 and 3, because 2 and 3 are part of the conspiracy, because they are obtaining the loans. And paragraph 11 of count 1 says that the purpose is to get the loans and spend the money.
Right, but then on 871, at the bottom half of the page, where the court, JA 871, where the court is talking about the burden of proof for the crime of conspiracy, namely bank fraud, you have to prove the following elements beyond a reasonable doubt.
Yes.
So wasn't there, don't we have a situation here, especially since the court at JA 870 talks about the purpose of the alleged conspiracy is violation of the bank fraud statute. They say that at 870 by referring to 18 U.S.C. section 1349. So don't we have a situation here where there was an incorrect instruction followed by a correct instruction?
Yes.
And what do we do with that?
That's exactly right. And what you do with that.
What do we do with that on plain error?
On plain error, it gave the jury an improper way to convict. And because the jury had an improper way to convict because of an invalid instruction, then you can't, and a general verdict, then you can't accept the verdict. In Pavlicek.
Okay, one question to piggyback, and I know
Certainly.
I'm interrupting, I apologize.
That's all right.
The verdict form itself says, as to count 1, conspiracy to commit bank fraud, guilty. How does that bear on our decision here?
If she's guilty of count 1, then they could also convict of 4 and 5. And so that's the conviction on count 1, and then they could also convict on 4 and 5. And we don't know whether in convicting on 4 and 5, they convicted based on the erroneous instruction or convicted based on the correct instruction. And that's why that case, Pavlicek, is important, because it was not known whether the jury convicted on a valid basis or an invalid basis. And they could have convicted on a valid basis, or they could have convicted on an invalid basis. And in that case, and in Hutchinson, you said that we have repeatedly said that when there is an error in the instructions on the elements, that is what the jury has to find, then on that basis, you cannot sustain the conviction. And you can't sustain a conviction on that basis because you don't know whether, as you said, incorrect or correct. Logic in jury life, I've done a couple, is that the jurors look at the counts 1, 2, 3, 4, 5. They don't look at 1, 5, 4, 2, 3, 6, 8. They do it in series. If they did it in series with the improper instructions, and they didn't have the indictment, so they couldn't look at it for themselves, if they did it in series, then they would have said, oh, count 1. The judge says if count 1 ends by a co-conspirator and he's a co-conspirator, okay, fine, that's the end of the story. We don't need to do anything else with counts 4 and 5 or 2 and 3. And that's, in my experience, is the logical way to look at it. But there are two different ways to look at it, and you can't say which. And I can't say which, and the government didn't say which. So we don't know which. So if we don't know which, and one was invalid and one was valid, you can't sustain it.
Well, if we agreed with you on counts 4 and 1, 4, and 5, what about 2 and 3? Were they valid?
2 and 3 are valid because they're substantive offenses of getting the loans, and they're mentioned in count 1 in paragraphs 11, 13 through 18, and then 21 was spending, but these 4 and 5 are not spending, they're transfers. And so transfers aren't spending. I mean, in plain English, you can't say transfer is spending. And they could have said transaction. They said in their brief that it was contemplated. Fine, it was contemplated, but it wasn't done. The grand jury didn't do it. They didn't write it. It wasn't in the indictment. And you can't speculate. You have to charge everything that you want them to prove in the indictment. She's entitled to notice, and she didn't get it. And the jury had an invalid instruction, as you've pointed out, and so which one did they follow? The logic would be they followed the count 1 and did that first, because that's the order of march that juries, I would submit respectfully, normally follow. And so if you can't say which, then you can't say good. And you can't speculate good. You can't guess good. Pardon me, that's not really appropriate English.
Thank you, Mr. Miller. We appreciate it. We're going to come down and cancel as soon as the clerk adjourns us sine die.
Thank you.
This honorable court stands adjourned sine die. God save the United States and this honorable court.